Hi, I'm Jim Covington. Today is August 11th, 2016. I'd like to welcome you to this week's issue of ISBA Statehouse Review. As the month of August rolls through, most of the bills that have been sent to Governor Rauner, he will have taken action on by the end of this month. And I would like to talk to you about 5 bills that were signed into law in the past week. The first one is amends the Open Meetings Act. It's Public Act 99-714, introduced by Representative Peter Breen from Lombard and Senator Chris Nybo from Lombard. It extends the time in which a person may file a civil action if a person files a timely request for review under Section 3.5 of the Act. This civil action must be filed within 60 days of the decision by the Attorney General to resolve a request for review by means other than issuance of a binding opinion under Section 3.5A. That takes effect immediately on August 5th, 2016. The next bill creates a electronic filing pilot program for the Illinois Domestic Violence Act. It's Public Act 99-718, introduced by Representative Mike McAuliffe of Chicago and Senator Julie Morrison of Deerfield. It authorizes the Illinois Supreme Court to adopt rules to establish a pilot program for the electronic filing of petitions for temporary orders of protection and the issuance of those orders by audiovisual means. Its intent is to accommodate litigants for whom attendance in court would be an undue hardship or risk harm to them. That takes effect January 1, 2017. The next bill amends the supplementary proceedings part of the Code of Civil Procedure. Throat got a little dry there. It's Public Act 99-744, introduced by Senator Ira Silverstein of Chicago and Representative Lou Lang of Skokie, and it makes the following changes to the supplementary proceedings. One, it clarifies that a petition to revive a judgment must be served and an order entered for a judgment to be revived. 2, it requires the amount of bond be posted after an entry of order of prejudgment attachment against the property of a debtor who may conceal the property or flee the state. 3, it makes taxable as court costs of all charges relating to the electronic filing of cases and pleadings. And 4, under current law, a court must vacate a judgment and dismiss the action when a release or full satisfaction of judgment is filed by the prevailing party. This provides that a judge may do so. And finally, 5th, it eliminates the sheriff's levy sale of corporate stock as superseded by the Uniform Commercial Code or a citation to discover asset statute. That takes effect on January 1, 2017. The next bill amends the forcible entry and detainer article, Public Act 99-753, introduced by Senator John Mulrow of Chicago and Representative Lou Lang of Skokie, and it changes a statutory notice of motion for the extension of an order of possession by replacing references to landlord with plaintiff, and that takes effect on January 1, 2017. The final bill I'd like to talk to you about amends the Mendelson case from the appellate court, and it's Public Act 99-743, introduced by Senator Ira Silverstein of Chicago, Representative Lou Lang of Skokie, and it seeks to reverse the holding of this case. It provides that the transfer of real property to a trust requires a transfer of legal title to the trustee, evidenced by a written instrument of conveyance and acceptance by the trustee. That provides that for any interest in real property to become trust property in a trust of which any transferor is a trustee, the instrument of conveyance shall additionally be recorded as the appropriate real property records. That takes effect on January 1, 2017 as well. Thank you for listening, and we'll see you next week.